email address that has been previously distributed to your offices, and we will circulate the materials to members and staff as quickly as we can. I would also ask all members, both those in person and those attending remotely, to mute your microphones when you are not speaking. This will help prevent feedback and other technical issues. You may unmute yourself anytime you seek recognition. I would also remind members that guidance from the Office of Attending Physician calls for all members to wear a mask even when they are speaking. I will now recognize myself for an opening statement. Fundamentally, Americans understand that a well-functioning legal system is vital to a healthy, thriving democracy. I think most of us share a vision of how our federal legal system should work to administer justice. This vision encapsulates a common-sense understanding of the importance of the constitutional right to petition the government for redress, to have due process, and to be entitled to a speedy and public trial. We imagine a system of open and equal justice accessible to everyone, where each and every case is closely supervised by a federal judge who ensures that the case is resolved both fairly and efficiently. But this vision falls apart if the judicial system doesn't have enough judgeships to ensure that disputes are not only resolved correctly, but also without unjustifiable expense and delay. That, unfortunately, is the crisis that we face today. We hear from small businesses and individual litigants who tell us that because there aren't enough federal judgeships, their disputes drag on, saddling them with crippling uncertainty and spiraling legal costs. We hear about how many years it takes to get a case to trial, settlement, or even an appellate decision. We hear from prosecutors that the delay makes criminal cases harder to prove, and we hear from defense attorneys that their clients languish in the limbo of pretrial detention. We hear about this crisis in the courts all the time, but it's been going on for so long that we've stopped treating it as a crisis. The last time Congress passed comprehensive judgeship legislation was 1990, just a year after the World Wide Web was created. A lot has happened in the ensuing 30 years, to put it mildly. The country grew by 75 million people. Our economy more than doubled. The world has become increasingly connected and complex, and the business of the courts have changed accordingly. But even after 3 decades of rising caseloads and increasingly difficult cases, the number of federal judges has stayed almost exactly the same. In some districts, the situation is even more dire. For example, the Northern District of Georgia, which encompasses Atlanta, hasn't received a new district court judgeship since 1978, even though the population of the district has increased exponentially and the regional economy has been transformed. Our federal district judges are extraordinary, but there is only so much that they can do to compensate for the fact that they've needed reinforcements for decades. And they often rue the techniques they've resorted to in order to try to manage their unmanageable caseloads. At the appellate level, some circuits have developed docket management practices that raise serious concerns about whether a two-tiered justice system has developed. One reserved for marquee cases, white shoe lawyers and wealthy litigants, and one for everyone else. All this makes clear that we cannot find a workaround to the fact that expanding the lower courts is decades overdue. The consequences of doing nothing are insidious and can become downright cancerous. When people lose faith in the federal court system's ability to resolve disputes justly, quickly, and inexpensively, our democracy suffers. We need to make sure that the federal courts can still operate according to the principle that justice delayed is justice denied. I look forward to hearing from our eminently qualified witnesses who will shed greater light on what it's like in a judiciary suffering from a chronic lack of judgeships, and who will discuss the importance of finally addressing this crisis. And it is now my distinct pleasure to recognize the ranking member of the subcommittee, the gentleman from California, Mr. Issa, for his opening statement.
Thank you, Mr. Chairman. And as you said, justice delayed is justice denied. Many people know that time is money. And in fact, money is the equivalent of justice delayed and thus denied. All of this has been a side effect of our inability to act in a timely fashion, as you said, for more than 30 years. Although in 2002, 15 judgeships were created, it only stemmed a small portion of the tide of ever-growing cases. But it also is time for significant reform. It's time for a serious conversation about the district judges and the circuit courts, but also about areas such as my own Ninth Circuit. The Ninth Circuit currently has 29 judges. Any reasonable expansion of the court would include additional judges on that court. And yet, the Fifth Circuit, which was last split in 1981, had only 17 judges and was split because it was reaching a point where it could not hold an en banc. The Ninth Circuit has not had a true en banc in decades. The fact is that the Ninth Circuit has the largest population and includes Alaska, Arizona, California, Guam, Hawaii, Idaho, Montana, Nevada, and the Northern Marianas, along with Oregon and Washington. It decides more than 11,000 appeals each year, and its backlog is pending typically 2 years or more. If there's a good example of denied because of delay, the Ninth Circuit is the poster child for it. It has been 17 years since we last made that any increase, which is the longest since 1789. More than 425,000 cases were filed in federal district court and the courts of appeals last year. These cases included time-sensitive civil rights claims, criminal prosecutions, environmental and consumer protection litigation, discrimination claims, challenges to government power, and holding corporations accountable for misconduct. With an insufficient number of judges to handle this caseload, ever greater numbers of people have been forced to seek alternate remedies, often to the detriment of what they would otherwise be entitled to, and without the precedent-setting decisions that would help in future cases. It is fine to consider outside jams and other resolutions, but it is not acceptable when there is no choice but to do so. While the decision for new judgeships is overdue, it is also important that we do it on a bipartisan basis. When Republicans were in the majority during the 115th Congress, I introduced the Judiciary Room Act, where we worked with our Democratic colleagues, many of whom are still here today, including our chairman of the full committee. This bill brought and added 52 permanent district court judgeships with a total of 66 judges authorized, including 8 temporary judgeships, into permanent judgeships. It was perhaps the boldest attempt in 30 years, and it did not fail for lack of a bipartisan nature. It failed for the effective and normal reason that we ran out of time to get it through the Senate. That should not happen again. We must work diligently in the early days of this Congress to send to the Senate a comprehensive bill that includes an expansion not only of those judgeships, but additional judgeships. What is also important, as I've spoken to the chairman of the subcommittee, is that we also have to send a clear message early on to the Transportation and Infrastructure Committee that these judgeships come with a need for offices and courtrooms. And those courtrooms can take 3 to 8 years to build. For that reason, we need to act resolute and quickly. We need to send a clear message that this is going to become law. Lastly, it is my fervent hope that we will use a similar compromise to the one we used in the 115th Congress when the House, the Senate, and the White House were all controlled by the Republican Party, that we have the effective date for at least some of these judgeships to be after the next presidential election, so that no one is being asked, is this a partisan appointment process or an expansion of the court for purposes of one side or the other, but rather the ongoing need that we will have even in 3 years from now. And with that, I thank the chairman for his indulgence and yield back.
I thank the gentleman from California, and I'm now pleased to recognize the chairman of the full committee, the gentleman from New York, Mr. Nadler, for his opening statement.
I thank the chairman for holding a hearing on this important issue that I know affects judges and litigants profoundly across the country. The growing crisis caused by the failure in recent decades to add new judgeships to the federal district and circuit courts. Article 3, Section 1 of the Constitution states that the judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as the Congress may from time to time ordain and establish. Pursuant to that grant of authority, Congress soon passed the first bill to create judgeships, the Judiciary Act of 1789. Thereafter, Congress regularly enacted judgeship bills to keep pace with the growing nation and the growing complexity of the federal docket. But that came to an end about 30 years ago, after the passage of the last major judgeship bill, the Federal Judgeship Act of 1990. That was the last time that any new circuit court judgeships were created. That was also the last time that any but a handful of district court judgeships were created, and there have been no new permanent district court judgeships added since 2003. This 18-year pause is the longest break in adding new district court judgeships since that first Judiciary Act back in 1789. Yet between 1990 and the end of fiscal year 2008, case filings have only continued to rise, growing by 15% in courts of appeals and 39% in district courts. In terms of caseloads, this means that the nationwide average caseload per judge is 521. This number is markedly higher in certain districts. As of March 2019, for example, the average for the District of New Jersey was 1,066. We will hear today from judges presiding in districts that are similarly bearing a higher than average caseload. And of course, this is to say nothing about whether the average itself is already too high. The problem is also acute in the courts of appeals, which are often effectively the last court to which most litigants will have recourse. The Court of Appeals have collectively heard around 50,000 appeals in recent years, compared to the less than 100 that make it to the Supreme Court docket. These numbers are dire, but statistics alone understate the depth of the crisis our courts face. What I hope to learn more about from the academics and honorable judges appearing before us as witnesses today is what these numbers mean in real terms. What is the impact of these growing caseloads on plaintiffs and defendants? Access to justice is a constitutional guarantee, but when this promise meets the reality of an overburdened and understaffed court, too often cases may be delayed or rushed and justice shortchanged. It is clear, for example, that long waits for civil trials can put pressure on plaintiffs to settle their cases, even if they believe they would win at trial, simply because they cannot bear the cost of drawn-out uncertainty and litigation. The impact on the criminal justice system can be even more stark. Although there are rules in place to at least prioritize these cases on the federal docket, the pressures of a burgeoning caseload on courts with too few judges can still place severe limitations on access to justice. We should also consider the impact on judges and how they must structure their practices to accommodate the growing caseload with no new colleagues to help shoulder the burden. At the appellate level, statistics point to circuit courts using a range of techniques to cope with the rising caseloads that depart from the traditional model of appellate decision-making. For example, while 1/4 of all opinions were published in 1985, Only 1 out of 10 is published now, meaning they are not considered to have precedential effect. This can lead to confusion in the lower courts and among litigants. In short, the efficient and fair administration of justice first and foremost requires enough judges. And from all indications, it seems like we do not have the right number today. I am pleased that we're having today's hearing to start to learn more about this important issue, and I hope, Mr. Chairman, that our work will not end here. Thank you, and I yield back the balance of my time.
I thank the gentleman from New York, and I will now introduce our witnesses. The Honorable Kimberly J. Mueller is the Chief Judge for the United States District Court for the Eastern District of California. She was confirmed to the bench in 2010 and assumed the role of Chief Judge in January 2020. Judge Mueller also served as a magistrate judge from 2003 to 2010. Prior to her appointment as a judge, Judge Mueller was in private practice in Sacramento, specializing in intellectual property litigation. Before becoming a judge, Judge Mueller served on the Sacramento City Council. Judge Mueller is a co-founder of the Justice Anthony M. Kennedy Library and Learning Center. Judge Mueller earned her BA from Pomona College and her JD from Stanford Law School. Welcome, Judge Mueller. The Honorable Larry A. Burns is a senior district judge for the United States District Court for the Southern District of California. Since January of 2021, Judge Burns was the chief judge on that court. Judge Burns was confirmed as a district judge in 2003, and from 1997 to 2003, he served as a magistrate judge. Prior to his time on the bench, Judge Burns worked in the office of the U.S. Attorney for the Southern District of California and the San Diego District Attorney's Office. Judge Burns received a BA from Point Loma College and his law degree from the University of San Diego School of Law. Welcome, Judge Burns. I'll now turn to my colleague, the gentleman from Arizona, Mr. Stanton, to introduce our next witness.
Thank you very much, Mr. Chair, for the opportunity to introduce a truly great Arizonan. The Honorable Diane J. Humitiwa was appointed to the United States District Court for the District of Arizona in 2014. She is a trailblazer as the first Native American woman and enrolled tribal member to serve as a federal judge. Before she was unanimously confirmed by the Senate to that post, Judge Humitiwa served as special advisor to the President and Special Counsel in the Office of General Counsel at Arizona State University and was a professor of practice at the Sandra Day O'Connor College of Law. Judge Humitiwa served in the United States Attorney's Office for the District of Arizona for more than a decade and was appointed by President George W. Bush to serve as U.S. Attorney from 2007 to 2009. Previously, she worked in private practice at Squire Sanders and Dempsey, where she represented tribal governments. She was also counsel to the U.S. Senate Indian Affairs Subcommittee, then chaired by the late Senator John McCain. Judge Humitiwa is a member of the Hopi tribe and served as an appellate court judge for the Hopi Tribe Appellate Court. She received her undergraduate degree from Arizona State University and her Juris Doctor from the Arizona State University College of Law.
Thank you, Mr. Stanton, and welcome Judge Humitiwa. Professor Brian T. Fitzpatrick is a professor at Vanderbilt Law School, where he holds the Milton R. Underwood Chair in Free Enterprise. Previously, he served as the John M. Olin Fellow at New York University School of Law. Prior to teaching, Professor Fitzpatrick clerked for Judge Diarmuid O'Scanlan. Let me do justice to that name. Diarmuid O'Scanlan on the U.S. Court of Appeals for the Ninth Circuit, and later for Justice Antonin Scalia on the U.S. Supreme Court. He practiced commercial and appellate litigation at the law firm Sidley Austin and was the special counsel for Supreme Court nominations to U.S. Senator John Cornyn. Professor Fitzpatrick earned his BS from the University of Notre Dame and his JD from Harvard Law School. Welcome, Professor Fitzpatrick. Professor Marin K. Levy is a professor at Duke University School of Law. She serves as the director of Duke's program in public law and is a faculty advisor to the Bolsh Judicial Institute. She has written extensively on judicial administration of the federal courts of appeals. Prior to teaching, Judge Levy served as a law clerk to Judge Jose A. Cabranes of the U.S. Court of Appeals for the Second Circuit and was an associate at the law firm Jenner & Block in Washington, D.C. Professor Levy received her BA from Yale, a Master's of Philosophy from King's College at the University of Cambridge, and her JD from Yale Law School. Welcome, Professor Levy. Before proceeding with your testimony, I hereby remind the witnesses that all of your written and oral statements made to the subcommittee in connection with this hearing are subject to 18 U.S.C. Section 1001. Please note that your written statements will be entered into the record in its entirety. Accordingly, I ask that you summarize your testimony in 5 minutes. There is a timer in the WebEx view that should be visible on your screen that should help you stay within that time limit. Judge Mueller, you may begin.
Chairman Johnson, Ranking Member Issa, members of the subcommittee, good morning. I am Kim Mueller, Chief Judge, Eastern District of California, covering 34 counties and 5 of the fastest growing cities in our state. As you've heard, I've been a trial judge just over 10 years, Chief Judge just over 1. We are a collegial, hardworking bench appointed by 6 presidents of both parties. But for 20 years plus, we've been in a judicial emergency. We cannot fulfill our obligations without congressional action creating new judgeships. Specifically, we need at least 5 new judges, and we have the infrastructure to house them and their staff right now. We urgently ask your help to meet the needs of the public we serve. Without your help, justice delayed is in fact justice denied. We are fighting a losing game, and with apologies to Lucy, that's exactly what Lucy says to Ethel in the unforgettable chocolate factory scene where chocolates race by on the assembly line too quickly to wrap. I promise we are not eating the chocolates, metaphorically speaking. We've had 6 authorized permanent judgeships since 1978, like the Northern District of Georgia, when our population was half of what it is today. Our caseload averages almost double the national average. We've also had 2 vacancies for more than a year, so our actual caseload right now is almost triple the national average. Although we are very productive, we are disheartened. We are 2nd worst on the list, 93rd out of 94 for time to close criminal cases. Many criminal defendants wait in jail for their trials. Civil cases languish. A few stories illustrate our plight. My first year as a district judge, my law clerks and I really were drowning. I didn't think of our workload as punishment, but our labors did and still do evoke Sisyphus, that ancient Greek king condemned eternally to roll a boulder uphill, only to have it roll down again when he reaches the top. This January, hope springing eternal, I asked my permanent law clerk how I could possibly get on top of my cases. He figures I need to issue dozens of lengthy reasoned orders every week, a third in hard cases. This, on top of administrative duties as chief, weekly criminal calendars, civil motion and evidentiary hearings, and trials. It is impossible for a single judge to do all this. My clerk recommended I spend my time informing those who can make a difference about our needs. Thank you for allowing me to follow his recommendation here today. Circumstances are particularly dire in our Fresno courthouse, where 1 judge is forced to do the work of 2 due to our vacancies. One of his caseloads is assigned to nobody, Judge None, N-O-N-E. The real judge holds criminal calendars 4 days a week. He cannot hold any hearings on civil motions and cannot set new civil trials. Each judge has a courtroom deputy, and That deputy manages our calendar and answers parties' questions. In our district, our deputies are more like ER triage nurses, I'm sad to say. My deputy receives many repeated, increasingly desperate requests for decision, particularly if settlement funds are at stake. All she can say is the judge will get to it when she can. She worries that parties feel ignored or the court doesn't care, even though we are working tirelessly. We do enjoy the service of senior judges who draw their retirement pay with no supplement. At this point, we have 3, the least since 1979. We value those 3. My immediate predecessor as chief, Judge O'Neill, who served our court for 21 years, observes, most judges work harder and faster when faced with our kinds of caseloads. We can, of course, and we do, but the pace is simply unsustainable. More of us are choosing to leave when we can. The departure of senior judges represents the loss of significant assets that will take years to rebuild once new judges are appointed. Our active judges are a good return on public investment. We are the 2nd most productive in our circuit and 8th nationwide. We implore you to meet our need for new judgeships. We already have the courthouses and the judges' chambers. They are empty. Only the human infrastructure is missing. The net new cost is likely modest here at best, especially given some extra temporary staffing we've been receiving. With new judges, instead of justice delayed, justice will be served. Thank you very much for your consideration. I'm happy to answer questions.
Thank you, Judge Mueller. And your situation is dire. And I want to thank you for the work that you and the other judges and all of the associated personnel are doing to achieve justice in your district. Thank you very much. Judge Burns, you may begin.
Well, good morning, Chairman Johnson, Ranking Member Issa, and members of the committee. Again, my name is Larry A. Burns. I'm recently a senior judge here in San Diego on the U.S. District Court for the Southern District of California. I've served our court since 1997, beginning as a magistrate and then since 2003 as a district judge. And as the chairman mentioned, I'm a former chief judge of our court. The Southern District of California encompasses a wide swath of territory. It stretches from the Pacific Ocean on our western border all the way to the Arizona border on the eastern border. It encompasses 2 large counties, San Diego County and Imperial County, home to some 3.5 million people. Our district includes 5 ports of entry that are contiguous with our border of along Mexico. The largest and the busiest of those ports is the port at San Isidro, California. It's the largest port in the world, as a matter of fact. Each day, more than 50,000 cars, 25,000 pedestrians cross into the United States through that port of entry from Tijuana, Mexico. And just to give you some perspective, in the standard vehicle lane coming in from San Isidro, it can take more than 6 hours of waiting to get across. Our district's jurisdictional reach also comprises many military installations, including the Naval Air Station at Coronado and the Marine Base camp at Camp Pendleton, California, up in the northern part of our district. Congress has authorized 13 active district judgeships for the Southern District of California. We've been at that number since 2003. That's the last time district judge positions were authorized for our court. Our court is a full-service U.S. District Court. By that I mean that our caseload consists of just about every type of criminal and civil case that's common in districts across the country. In addition, we're one of the 5 Southwest border courts, a designation that I mentioned which greatly impacts our caseload. I won't bore you with tedious statistical data, but I want to provide the subcommittee with an overview of the trends in our caseload, which reflect an increasing demand on the part of our court for more judges. National statistics since 2003, the last year we had a judgeship bill, through September of 2019, show that the number of total cases filed in the nation has risen by 13.6%. California alone, the district courts here and the circuit court handle 10% of the nation's caseload. During the 16-year period since we last had judges, the caseload in our district has increased by 17%. And we've seen weighted filings. Weighted filings are the basic caseload assessment that determines the average amount of time it takes to complete a case. Weighted filings have increased by 30%. In 2019, our district judges' weighted caseload was 634 cases per judge, an increase way over what we've been at, and well above the national average of 535 cases per judge. Between 2017 and 2019, our court's criminal filings rose 30%. The effects of the increase on our caseload have been profound, and they inexorably lead, as the chairman mentioned and ranking member mentioned, to delay of cases, particularly the civil cases. The average time to adjudicate a civil case in district court across the nation is about 2 years. In our court, it's unfortunately about 37 months, which is way too long. As members of this subcommittee well know and have alluded to, long delays in adjudicating cases can lead litigants to conclude that the expense and the passage of time makes it impractical to continue the litigation and leaves them the only option of foregoing their day in court. These outcomes lead to an erosion of trust in the judiciary and in the judicial process itself. Our criminal caseload is absolutely staggering here. Most of the cases fall into two categories: criminal immigration and border drug cases, and they predominate the workload of our district judges. We're assisted by 9 senior judges, but it's important to remember that those senior judges have the prerogative of choosing which cases that they'll handle. Some in our district don't choose to handle the immigration cases or the border cases. And also the term of the senior judges is up to them. They can stop at any point. So quite simply, we need more district judges if we're to continue to meet the demands of the increasing caseload. There's an urgent need in our district, as there is, as Judge Mueller mentioned in her district, for more judges to handle the cases and to process them efficiently. Thank you. I'm available to answer questions at the appropriate time.
Thank you, Judge Burns. Next, we will hear from Judge Humitiwa. Judge Humitiwa, you may begin.
Chairman Johnson, Ranking Member Issa, and members of the subcommittee, I'm honored to testify on the dire need for more district judges in Arizona. As of September 2020, Arizona is 5th in the nation for criminal felony filings and 16th for civil case filings. Since 2003, the JCUS has consistently recommended 3 to 6 new judgeships for Arizona, yet it has been 19 years since a new judgeship was authorized. Our need stems Arizona's geography, the tribal presence, and a growing population. 38% of Arizona land is under federal superintendents. Another 27% is tribal land. Arizona also has a 370-mile-long border with Mexico, and it is among the top 3 fastest growing states, home to over 7.4 million people. Recent data also shows sustained and significant growth in Arizona's tribal nations, reaching approximately 425,000 persons in 2019. Our caseload continues to grow in complexity and volume. Federal court management statistics from 2018 through 19 show Arizona had a weighted caseload of 800 filings per district judge, which is 5th highest in the country. Arizona's weighted filings were 86% higher than the general standard of 430 cases per judge and 50% higher than the national average of 535. The paucity of district judges uniquely impacts Arizona's 22 tribal nations. In states like Arizona, the federal district court is the felony criminal court for tribal nations. We adjudicate crimes arising in Indian country under the Major Crimes Act, and Congress has seen fit to enact additional federal crimes that apply to Indian country, including felony child abuse and neglect, sexual abuse, and domestic violence offenses. With more crimes come more criminal proceedings. Northern Arizona in particular demonstrates this need. The region covers 5 counties and 10 Indian nations. From 2016 to 2019, Northern Arizona's criminal filings increased 13%, and its civil case filings increased 21%. In 2019, the region's weighted caseload was 774.6, surpassing the national average. If it were a judicial district, it would qualify for at least one new district judge under the U.S. Judicial Conference standard. While there is a federal magistrate judge in Flagstaff, home to Northern Arizona's only federal court, magistrate judges have limited authority. They handle the preliminary stages of felony criminal cases and then must transfer the case to a Phoenix district judge. And many civil cases move south to Phoenix for all pretrial and trial proceedings because magistrate judges cannot dispose of civil cases without the parties' consent. Arizona's courtrooms in Phoenix and Tucson pose logistical challenges to those living in Arizona's tribal nations. Criminal proceedings such as grand juries, trials, and sentencings usually take place hundreds of miles away from the accused's family, the victims, and the impacted community. And the demographic reflected in a grand jury or trial jury pool seldom resembles the accused peers or the population in the affected community. When we can, we try to conduct proceedings in the Flagstaff magistrate judge's courtroom. This is more convenient for the accused's family, the victims, tribal and federal law enforcement, and the Northern Arizona jury pool. But journey 148 miles north necessarily impacts our other judicial responsibilities. The distance from Northern Arizona also inhibits proceedings when we work from Phoenix. A federal judge in Phoenix cannot summon a supervisee from the Navajo Nation or White Mountain Apache Nation and expect him or her to appear the next day. Federal location monitoring is simply not practical up north, and Arizona ranked the 3rd highest district for supervised release violations from 2013 to 2017. In Arizona, the status quo simply cannot meet the constitutional mandate to administer meaningful justice to all. And I am happy to answer any questions that you have of me. Thank you.
Thank you, Judge Himi-Tiwa. Next, Professor Fitzpatrick, you may begin.
Thank you, Mr. Chairman. It's an honor to be back before this subcommittee. I'm a professor of law at Vanderbilt Law School in Nashville, Tennessee. I have practiced in the federal judiciary. I was a law clerk in the federal judiciary, and now I research and teach about the federal judiciary as a professor. I want to focus my testimony on new judgeships for the courts of appeal. And in particular, I want to focus on one court of appeal, the Ninth Circuit. I want to tell the committee that if you decide to create more judgeships for the Ninth Circuit, I think that you will also be required to restructure the Ninth Circuit, and I think you should be aware of that as you go forward. The Ninth Circuit is the largest federal court of appeals in American history. It has 29 active judges, many more part-time senior judges. It covers 20% of the country, 60 million people. Because the Ninth Circuit decides cases in panels of only 3 judges, this means that 2 judges can end up deciding the law for 60 million people. The circuit should have been restructured long ago, and the need to do so will be even greater if you add more judges. The truth is that the only reason the circuit has not been restructured, in my view, is because it's been mired in partisan politics for so long. The reason why it's been mired in partisan politics is because 10 Ninth Circuit judgeships were created when Jimmy Carter was president. and this has led to a predictable partisan imbalance on the court ever since then. And this predictable partisan imbalance has led one party to want to break up the Ninth Circuit and the other party to do everything it can to keep the Ninth Circuit intact. I think this is very unfortunate because if there had been no partisan imbalance that was so predictable, I think the Ninth Circuit would have been restructured long ago. And the reason is there are very good government reasons to restructure the circuit. There have long been complaints that the Ninth Circuit size makes it the slowest court of appeals in America. There have long been complaints the Ninth Circuit size makes it difficult for the judges to keep track of what the others are doing, leading them to issue decisions that inadvertently conflict with one another. But I want to focus on another problem that I think is caused by the Ninth Circuit's unprecedented size, and that is it leads to more erroneous legal decisions being made. And we should care about that because 60 million people are affected when the Ninth Circuit makes mistakes. And it's hard to deny the Ninth Circuit makes more mistakes than other circuit courts. For decades, it has been the most reversed circuit by the United States Supreme Court. I put the data on that in my written testimony. Part of the reason it makes more mistakes is because bigger circuits end up more frequently picking by random 3-judge panels led by odd or outlier judges with non-representative views of the bigger court. You can show this phenomenon with simple math, and I do it in my written testimony. But part of the reason why the Ninth Circuit makes so many more mistakes and ends up getting reversed more often by the Supreme Court is because the Ninth Circuit is so big, it cannot correct mistakes by its 3-judge panels by going en banc. The way that circuits correct mistakes is through en banc rehearing. But the Ninth Circuit is the only circuit in American history that has become so big it cannot go en banc with the full court. Instead, it goes en banc with only 11 out of 29 judges. That means 6 judges, a majority of 11, can control what the Ninth Circuit does, but those 6 judges can be unrepresentative of the full 29. This is not just theory. There have now been some excellent empirical studies done by scholars that show the Ninth Circuit's size is what leads it to get reversed more often. The best study is done by Dr. Kevin Scott. He's a political scientist who used to work at the administrative office of the federal courts. He's now a chief of statistics in the Department of Justice, and he's used regression analysis, and he's shown the Ninth Circuit's inability to go en banc with the full court has led it to get reversed 10 extra times every year by the United States Supreme Court, 10 times just because of its limited en banc. I'm out of time. I'm happy to take questions. Thank you very much for having me.
Thank you, Professor Fitzpatrick. Professor Levy, you may begin.
Chairman Johnson, Ranking Member Issa, and distinguished members of the subcommittee, thank you so much for the opportunity to testify today regarding the need for additional judgeships on the federal courts of appeals. Quite simply, it is an honor to be here. I'm sure that I do not need to stress to this subcommittee the importance of the federal courts of appeals and the functioning of our judicial system and in our government as a whole. According to the Administrative Office of the U.S. Courts, the 13 courts of appeals collectively decided more than 50,000 appeals in 2019. By contrast, the Supreme Court decided just 61 cases in October term 2019, only 50 of which were from federal courts. Accordingly, the courts of appeals have effectively become the courts of last resort for tens of thousands of litigants across the country. It is therefore critical that they have sufficient resources, including, first and foremost, a sufficient number of judges. And it's my belief, based upon years of research, that they currently do not. By way of history, when the courts of appeals were created in 1891 by the famed Everett's Act, they began with just 19 judges. And then over the next 100 years, Congress consistently and frequently authorized new judgeships for those courts. Indeed, as I tell in my written testimony, Congress expanded the courts nearly 30 times over the decades that followed, eventually growing the regional circuit courts and the federal circuit to 179 judges by 1990. The reason for this regularized expansion is plain. Congress grew the courts to try to keep pace with a dramatically rising caseload. In 1950, when the great learned hand was on the bench, there were just under 5,500 filings in the federal courts of appeals, or about 73 per active judgeship. By the late 1970s, the case filings had nearly quadrupled, and they doubled again by 1990 to just over 40,000. Throughout this time, Congress added judgeships again and again, including several omnibus judgeship bills. In 1978, as we've already referenced here today, during the Carter administration, Congress created 35 circuit court judgeships. In 1994, during the Reagan administration, Congress created 24 more, and in 1990, during the Bush administration, Congress created yet 11 more. And through these congressional interventions, the number of filings per judgeship, though it continued to climb, was kept somewhat in check. By 1990, it was 237 per year, importantly below a benchmark that the Judicial Conference had set of 255. Unfortunately, though, Congress has not added a single judgeship since that time, but the caseload has risen still. In 2019, there were just under 51,000 cases filed in the federal courts of appeals. That's an increase of approximately 20% above where we were in 1990. This puts us at 284 filings per judgeship. And in certain circuits, of course, that figure is considerably higher. Indeed, it is currently over 350 per judgeship in the Ninth Circuit, 410 per judgeship in the Fifth, and 450 per judgeship in the 11th. As I'm happy to talk about more during questions, we know what happens when we ask courts to do more without concurrently giving them more resources to do it. Courts must adapt, which means relying more heavily on case management strategies, and in particular, sending a smaller percentage of cases to oral argument, having a larger percentage of cases go first to staff attorney offices for consideration, and then ultimately having a larger percentage of cases resolved by short, and in some circuits, even cursory unpublished decisions. To provide just one illustration, just after the last court expansion in 1991, 45%, or close to one half of all cases decided on the merits, received oral argument. Today, that figure is less than half. Only 1 in 5 cases decided on the merits are heard before a panel of 3 judges. Now, as we know, truncated review has its effects and its costs. It can leave parties feeling like they did not have their day in court. Moreover, judges and scholars alike have raised accuracy concerns in addition to these process-based ones. The court should not be put into this position. In sum, Congress should return to its earlier practice and authorize new judgeships for the courts of appeals consistent with their caseload needs for the courts and for all of those who come before them for the just resolution of appeals. Thank you, and I look forward to your questions.
Thank you, Professor Levy.
Mr. Chairman.
Yes,
At this
gentleman is
time-
recognized.
Thank you, Mr. Chairman. At this time, I'd like to ask unanimous consent that Representative Sparks, who's a member of the full committee, be allowed to sit in and hear the testimony today and participate only if time is yielded by another member of the subcommittee.
Without objection, so ordered.
Thank you, Mr. Chairman.
We will now begin under the 5-minute rule with questions, and I will begin by recognizing myself for 5 minutes. Professor Levy, I understand that because of the crushing workload, a large number of courts of appeal judges are increasingly relying on staff attorneys to both screen cases and write opinions, which often become the basis for final case disposition. Can you talk about that practice, what it looks like, and how it differs from the process for cases where a law clerk assigned to a particular judge might work the case?
Sure, I'd be happy to. So I think the starting point is, as you said, to think about staff attorneys in comparison to law clerks. So law clerks, as we know, are hired directly by judges, and they're supervised directly by judges. So the judges will give their law clerks instructions about a particular case. The law clerks will then work with the judges to draft an opinion. But again, they're being directly supervised by the judges. In contrast, we can look to staff attorney offices. So it's hard to get great statistics on this, but according to a book authored by Judge Posner 3 years ago, there are over 400 staff attorneys across the country today. You can think about these as almost mini law firms within a particular circuit. These staff attorneys do not work directly for any judge. Instead, they're supervised by a head staff attorney. And so what this means is cases come in, there's variation from circuit to circuit, but cases will come in. The staff then, in many circuits, will screen those cases. They will make the determination at the outset if the case will go to oral argument or not. And then in many cases, they will end up writing a memo and draft a disposition, which a panel of judges will then consider. So hopefully that gives you some sense of some of the key differences there.
So what we have is a situation where a staff attorney, not accountable to any particular Court of Appeals judge, is reviewing cases and actually making a recommendation as to the final disposition of the case. And this is in the courts of last resort in our federal government.
So that's right. What we have is a situation in which the staff are, again, first screening the cases, but then ultimately drafting the dispositions. The judges, of course, as we said, do review them, and the judges can decide if a case really should be set for argument instead. But it is an enormous amount of power that's given then to staff attorneys. That's absolutely right.
And the staff attorney positions, I suppose, have increased. In other words, we have more staff attorneys now because of the increased caseload that the courts of appeals are faced with, that they must manage. And the staff attorney route is a mechanism whereby Court of Appeals judges can manage the work that is hoisted upon them.
Yes, that's absolutely right. So these staff attorney offices, I should say, were first authorized by Congress in 1982, and they were initially designed for the review of pro se prisoner cases. That has expanded significantly. Both the offices themselves have expanded in size, but also the role of staff attorneys has expanded considerably since that time as the caseloads have risen.
Thank you. Judge Mueller, can you talk about how, in your view, we should be thinking about the cost-benefit analysis of adding new judgeships? Obviously, there are costs involved in the addition of new judgeships, but in your view, are those costs outweighed or at least balanced by the benefits of right-sizing the judiciary?
Thank you for that question, Chairman Johnson. Absolutely, we see district judges as investments. I don't believe that we are alone, but trial courts are the foundation of the federal judicial system. We are the courts that the public most likely sees as jurors, as parties, as members of the public who at times still crowd into our, when we don't have the coronavirus pandemic, still crowd into our public galleries to watch proceedings. We are the foundation, and we are essential infrastructure. We have the we have the physical infrastructure in our district, as I said. So we need the human infrastructure to complete the infrastructure picture. And we believe it is essential to look not only at costs, but also the benefits that we bring to the table. Thank you.
Thank you, Judge Mueller. At this time, I will now recognize the gentleman from California, the distinguished ranking member of the subcommittee, Mr. Issa, for 5 minutes.
Thank you, Mr. Chairman. And I want to thank all of our witnesses. This is one of those hearings where we hear each of you, and I believe there's broad agreement here on the dais on both sides. Judge Burns, if I can go to you first, I want to first thank you for staying on the bench. I realize that you could be making more money somewhere else, but you're staying and handling a caseload. Specifically in the case of the San Diego district, if one of the high-tech capitals of the country there in San Diego, if a patent case comes up, could you just briefly tell us what the process would be and how the ability to take a patent case to trial in the Southern District, how it's impacted by the shortage of judges?
Thank you, Congressman Issa. We have a patent program here where patent cases in particular are channeled to certain judges who have expertise or have great interest in them. Doesn't mean that those cases are expedited. They're not. They fall in line with the other civil cases. And as you know, patent litigation is incredibly complex, more complex, I'll say, than most civil cases. And so it takes a lot of time. The issues are difficult ones. A Markman hearing, which is a determination of just what the patent covers, can be a long and contentious hearing. It's a special hearing that's different from other pretrial hearings, so it's a feature of patent cases that is unique, doesn't apply in other civil litigation. But the general effect of this crushing caseload, particularly the criminal cases, is that patent cases and all civil litigation are given a back seat. And it takes more time than it should to resolve such cases.
Thank you. Briefly, I mentioned this in my opening statement. The Southern District is like some other districts where if we gave you the 3 or so more judges at a minimum, I think it's 6 actually, that the Judicial Conference thinks you should have, you would have no courtrooms for them. Could you briefly give us your timeline, cost, and how you would deal with getting those courtrooms if you were given the judges today?
We have 3 court facilities in the Southern District. As with Arizona, we have one outlying court in El Centro in Imperial County, staffed by a magistrate judge. And then we have 2 courthouses here, one built in 1976, the Schwartz Courthouse, and then the newer one, the Carter Keep building, which was opened in 2012. When that building was designed, it was designed for more courtrooms than ultimately were authorized in the bill authorizing building the courtroom. We had 6 to begin with. Recently, the House has authorized 2 additional courtrooms. Construction of those courtrooms is underway now, but we have room for expansion within our existing facility. There's several floors here with high ceilings and people in cubicles, IRS and otherwise, now occupying that space, but they can be readily converted to courtrooms for district judges, magistrate judges.
Thank you. Professor Fitzpatrick, as you know, you noted in your openings, in your statement, there was a partisan history to the Ninth Circuit. Is it fair to say that today the Ninth Circuit is relatively balanced, and perhaps this is the most nonpartisan time to reorganize the Ninth Circuit?
I think that's right, Congressman. I think that we are close to parity in the Ninth Circuit now, and therefore this may be an opportunity for the Congress to make changes without obvious partisan implications helping one side or the other. So I think this is an optimistic time to do the work that should have been done a long time ago to restructure the circuit.
So if we are not to change the Ninth Circuit and expand it, as the Judicial Conference wants, to about 33 judges, would you opine on the fairness of, instead of remaining with so many other districts, if we collapsed other districts to similarly have 33 judges, or perhaps eliminated circuits altogether, what the effect would be?
Well, I think we would multiply the problems in the Ninth Circuit all across America. I think we would have slower appeals all across America. I think we would have more inconsistent rulings within a circuit all across America. And I think there would be more mistakes made in other circuits if we made them all gigantic circuits similar to the Ninth Circuit. So I just think that would multiply problems rather than multiply solutions.
Thank you. I yield back.
Gentleman's time has expired, and gentleman yields back. At this time, we will recognize the gentleman from Florida, Mr. Deutsch. At this time, I'm sorry. We will recognize the full committee chair, Jerry Nadler, for 5 minutes.
Well, thank you, Mr. Chairman. Before I begin with my questions, I want to thank all the witnesses for their testimony today. Judge Mueller, I understand that although delay in civil cases is often more common and apparent than in criminal cases, delays in criminal cases nonetheless are occurring. especially where judicial shortages are most dire. Can you put into real-world terms what these delays mean both for criminal defendants and for the prosecution in trying these cases?
What the court sees in terms of the delays in criminal cases is on a number of fronts. As I said, we are 93rd of 94th currently. We were 94th last year, so we're at the bottom. For criminal defendants, even though the Bail Reform Act appears to favor release when possible, detention is common, and our district has a high detention rate, higher than the national average. We're over 55% of criminal defendants pending trial who are detained in local jails up and down the Central Valley. Oh, they wait longer periods of time, as the stats show, often nearing 2 years before they can go to trial. And in terms of the prosecutors, they are very anxious to see that number go down. It's not a problem. Resolution effectiveness of criminal justice in our district. Did you also want me to address civil cases?
What? No.
Did you also wish me to address civil cases?
No, thank you.
All right.
No, thank you.
Thank you.
Judge Humitiwa, you referenced in your testimony the disappearing trial and the role that judicial understaffing plays in causing this trend. Can you elaborate on this point and why more trials would be good for the judiciary and for litigants?
Yes, I would be happy to. I think it's no secret that over the years, in order to handle our huge caseloads, district courts and judges have tried to find ways to make it more manageable and really try to force the litigants themselves to resolve their issues short of trial, and to really whittle down the paper that is filed with summary judgments or dispositive motions. And in many, many instances where you have litigants for the first time and their clients wish to appear and have oral argument, it is just not feasible when you have a very heavy docket. And so we've adopted rules, for example, here in Arizona, that permit a district judge to say that oral argument is not necessary because the matter has been fully briefed. I fear that in many ways, litigants see that the courtroom doors are closing rather than opening, and that in many instances, litigants and clients and the parties involved never step foot in the courtroom. And as a result of that, you have an decrease in practice, actual litigation practice of people that are actually going to law school and graduating with the hope of becoming a litigant. And so it really does damage to what our courtrooms are meant to be, public forums for airing these grievances, and to be able to have the ability to orally argue your case, to make persuasive points that may not otherwise resonate in a paper form. So I think there are multiple issues that arise from that.
Thank you. Professor Levy, I understand that there's been an increase over the last 30 years of unpublished decisions by courts of appeals as a way to manage the caseload. Can you explain that trend and what implications it has? Is this something that we should be thinking about as we look to assessing the need for additional judgeships in the courts of appeals?
Sure, I'd be happy to. So no surprise, as the courts began to experience the rising caseload, they had to find some way to save time. It's been said that judges spend as much as 50% of their time writing opinions, and so it's not surprising that they would then turn to writing shorter, unpublished decisions as a way to cope. I would say now, so again, we see on decisions on the merits, right, we almost 90% of cases are decided by unpublished decision. And I think the real loss that we should be focused on is the content of some of those cases. So Professor Merritt McAllister has done a great recent study on this. She looked to the Fourth Circuit a few years ago. In 1 week, the Fourth Circuit issued 100 decisions. Only 2 of those were published, so only 2 made law. And of the rest, there was a sizable percentage that did not contain independent reason giving. And so simply said, for example, the court found no error, or for the reasons that the district court stated, the case was affirmed. That, I think, is a cause for concern. We don't have independent reason giving by the courts. I think the litigants then don't feel like their cases have truly been heard. And that's a cause for concern for process values and legitimacy as a whole.
Thank you, Mr. Chairman. I yield back.
Gentleman yields back. At this time, we will recognize the gentleman from Ohio, Mr. Shabbat, for 5 minutes.
Thank you, Mr. Chairman. Professor Fitzpatrick, let me begin with you. And I'll start by noting that Democrats took over the House of Representatives over 2 years ago, back in 2018. They took over this committee. We have a Democratic chair of this subcommittee and the overall Judiciary Committee. They set the agenda. They determine what topics we're going to talk about. And whereas Democrats have espoused the point of view that we needed to add federal judges, they didn't hold a single hearing in this committee during the last 2 years when they determined what the agenda is. Neither did they bring a single piece of legislation to the floor of the House in order to get new federal judges. I wonder why. We had a Republican president, Donald Trump, who was at the White House, and he would have been able to nominate those judges. And now we have a Democratic president. So one of the first orders of business of this committee, which of course the Democrats still control, is to hold a hearing with the goal of adding new federal judges. Now, Professor Fitzpatrick, let me ask you this. For the purpose of fairness here, what would you think about the idea of staggering any new judgeships over several different administrations? Now, we don't know who's going to win the upcoming election, so you don't know for sure how that would all play out. But in order to have at least a balance, that you don't, for example, as you mentioned earlier, where you had a whole slew of either liberal or progressive judges that one puts on the bench, if you did it over a period of time, what about that idea? And I believe Mr. Issa and Senator Todd Young over in the Senate have put forth a proposal along those lines. Could you comment on that?
Yes, I can. I think that's the right way to do this. I don't think the right way to do this is to add a bunch of judgeships that's going to have a predictable partisan effect. The right way to do this is to push off the effective date of the new judgeships until there is a new presidential administration, so both parties have a chance to have some of their people put on the bench. We don't want to recreate the mistake we made with the Ninth Circuit during Jimmy Carter's administration. The Ninth Circuit has been a political football for decades because all those judgeships were created for President Carter, and now the Ninth Circuit has been a predictable, partisan, imbalanced court for decades. So push it off. Neither side knows who will benefit politically. That's the fairest way to do it, and the way to do it that doesn't mire our courts in this partisan warfare.
Thank you. Let me follow up, Professor. You mentioned in your testimony that the Ninth Circuit has long had the highest percentage of its decisions reversed by the Supreme Court of any other circuit, substantially higher, not just by a small margin, but substantially higher. What impact does that, having such a high reversal rate, or a reversal at all, what impact does that have on the litigants, the public, the taxpayers, and the people that foot the bill for government? And the court system obviously is part of that government, and a reversal obviously, that the process goes on even longer. Could you comment on that?
Yes, I mean, certainly for the litigants in a given case, having to go up to the Supreme Court to get the Ninth Circuit corrected takes time and money, but there are effects beyond that. The law in the Ninth Circuit is less coherent because it's subject to Supreme Court reversal more frequently. You're never sure when you get a Ninth Circuit ruling how long it's going to be around. What's the shelf life of the Ninth Circuit ruling, because the Supreme Court reverses it more often. But even more importantly than all those things, I think the Supreme Court reversal rate is a signal that the Ninth Circuit is making more mistakes. And what I worry about is all the mistakes the United States Supreme Court cannot catch. The Supreme Court hears very few cases every year. It can't correct all the mistakes of the Ninth Circuit or the other circuits. And so I worry about 60 million Americans having to live under erroneous legal rulings more often than their fellow citizens in other parts of the country.
Thank you very much. My time's expired, Mr. Chairman. Yield back.
I thank the gentleman from Ohio, and Professor, you've just made the case for expansion of the U.S. Supreme Court so that it can hear more cases. I don't know if you intended to do that or not, but at this time I will recognize the gentleman from California, Mr. Liu, for 5 minutes.
Thank you, Chairman Johnson, for holding this important hearing. Thank you, Chairman Nadler, for your leadership on the Judiciary Committee. My wife externed for a federal district court judge, and I was a law clerk for a Ninth Circuit judge out of law school. So first of all, I want to say thank you to the judges that we have here today for your public service and for what you're doing and for testifying. I also do want to just start off by countering the notion that the Ninth Circuit's 80% reversal rate is somehow year after year. That's just not true. The Washington Post and the AP and PolitiFact have looked at that statistic, and it is true that in 1 year, one term, 2015, 2016, the Ninth Circuit had a 79% reversal rate. It's also true that in that same term, that was not the highest of any circuit. And in fact, since 2005, the Ninth Circuit has never been the highest circuit in terms of cases reversed by a Supreme Court. So what these newspapers are saying is basically that Mr. Fitzpatrick is misleading us with his statistics. Now, that doesn't mean I don't think the Ninth Circuit should be smaller. I'm open to arguments that the Ninth Circuit, for efficiency reasons, maybe we do want to either split it up or move some of the states to another circuit. So I want to commend Ranking Member Issa for agreeing that we need to increase the number of judges at the appellate and district court level. It's also clear to me that perhaps the U.S. Senate might require some changes to the way we have our circuits. So with that in mind, I'm going to ask Judge Mueller, what do you think about proposals to either split the Ninth Circuit or take some states in the Ninth Circuit and shift it, let's say, to the 10th Circuit?
Congressman Liu, I have to admit I did not prepare for questions on that issue as a trial court judge in the trenches who follows the law of the controlling circuit and, of course, the Supreme Court when it has clarified the law. And so I'm not really prepared to give you a cogent answer to that question today. I hope you'll accept it.
If you could just submit some testimony after the fact to us, that'd be great. So Judge Burns, let me ask you the same question. Do you have any thoughts on proposals to split the Ninth Circuit into two different circuits or taking some of the states and shifting it to, let's say, the 10th Circuit?
Thank you, Congressman Liu. I have personal opinions about that. Over my term as a district judge, I frequently sat as a visiting judge with the Ninth Circuit. One of the downsides to the size of the circuit and the caseload is that the Ninth Circuit is required frequently to bring in district judges. So we have judges who have no historical connection, no everyday connection to the Ninth Circuit that are coming in and deciding cases. They're coming from all over the country. Many times they're district judges from the opposite side of the United States. I think that's probably a downside. The other observation I'd make is this. I serve on a very collegial court. We meet once a week. We have judges meetings. The judges, although we're not always of the same philosophy or the same political persuasion, we enjoy each other's company. We respect one another. The randomness with which Ninth Circuit judges can be on the same panel with one another because of the size of the court is very much compromised. I saw a statistic recently that said it's once every 3 years that one judge of the Ninth Circuit will sit with another judge of the Ninth Circuit. That's how random it's become. And I think you lose something as a circuit court when you don't have the opportunity for that kind of cohesiveness. So those are general observations. Again, they're matters of personal opinion born out of my anecdotal experience in sitting with that court.
Thank you. And then, Mr. Fitzpatrick, I don't mean to imply that you're trying to mislead us. I'm just saying that one of the sentences you said is a misleading statistic. I'm also going to give you the opportunity to respond to what I said. So if you would like to go ahead.
Congressman, that's very kind of you. I appreciate that. And I just think we're talking about two different statistics. I think the statistic that you're talking about is, given the cases the Supreme Court accepts for cert, how many of them end up getting reversed. The statistic I was talking about was, given how many appeals the Ninth Circuit decides every year, how many of those cases end up getting reversed by the Supreme Court. So you're absolutely right. In any given year, the Ninth Circuit is not the most reversed of the cases accepted for cert by the Supreme Court. I do think if you look at the number of reversals compared to the number of appeals decided by the Ninth Circuit every year, those that are granted cert and not granted cert together, the total number of appeals, I think you'll find that the reversal rate is the highest. But it's an open question which of those statistics is more meaningful to us. And so I don't begrudge you your focus on the statistic that you did.
Thank you very much. Back.
We will now resort to the gentleman from Texas, Mr. Gohmert, for 5 minutes.
Thank you, Mr. Chairman. I appreciate you resorting to me. Judge Mueller, are there dramatically more cases being filed this year than you've had in prior years?
Congressman, that's directed to me, is that correct?
Yes.
I would say that our caseload is essentially maintaining, but we have not seen a steep rise yet in light of the pandemic. If that is a part of your question, we are bracing for an increase in filings. As with any crisis, we see cases follow. So as with the mortgage crisis, we had a steep uptick in cases. Our actual cases per judge spiked to almost 1,500 cases per judge. Right now, our actual caseload per judge is around 1,200 cases. We expect that that number will go up with bankruptcy filings, employment case filings. So we're staying tuned, unfortunately.
Yeah. Okay, thank you. I just wondered if, there was a dramatic rise, that maybe that could justify why we didn't have a hearing for 2 years and y'all were in desperate need of new judges, and now all of a sudden, within 6 weeks, we have this hearing. Anyway, I guess.
Would the gentleman yield?
Yes.
I was gone for 2 years, Louis. I'm back.
Yeah, but you aren't the one that sets up the hearings the last 2 years nor now. So it's good to have you back. But I am concerned about that. Why, if there was such an emergency, we didn't have them before. But Professor Fitzpatrick, the last numbers I'd seen from 2017 indicate that the Ninth Circuit has more than twice as many cases as the next largest circuit, being the Fifth Circuit. And that's reflected also in the number of cases that are filed. When you look at the cases filed in California and the cases filed in the rest of the Ninth Circuit, what do you think it would look like if the Ninth Circuit were divided and a new circuit created, one for California? Because last I'd seen, more of the cases the Ninth Circuit had were from California compared to all the other states in the Ninth Circuit. What do you think that would look like to have California be the Ninth Circuit and then a new circuit take the other the cases from the other states?
That's one of the leading proposals on how to split the Ninth Circuit, is to make California into its own circuit. We've never done that before. We've never had a circuit confined to a single state. And the truth is, California is so big that it would have a lot of judges even in a California-only circuit. So I don't know if we actually end up decreasing the size of the Ninth Circuit that much if we keep California intact. I actually prefer another solution, which is also not ideal, and that is to break California across two different circuits. So Northern California would join the states in the Northwest, Southern California would join the states in the Southwest, and you'd have a circuit that divides California in the middle. That's also never been done before, but I think it would allow us to get each circuit down to a more reasonable size. And I don't think it is impossible to deal with the fact that federal law may vary from San Francisco to LA for a while. Right now, federal law varies from San Francisco to Salt Lake City for a while, because they're in different circuits. State law vary from one part of California to another for a while. I'm sorry, Congressman.
Yeah, and I appreciate that. It does seem that more of California's population's in the southern part of California, but going back to what my friend Congressman Lou referred to, the year that there were so many reversals of the Ninth Circuit, I was thinking maybe the appropriate remedy would be to confine the Ninth Circuit to controversies that arose in its own courthouse and then create another circuit for everything else in the Ninth Circuit. But my time has expired, and I'll yield back.
I thank the gentleman from Texas. We will now move to the gentleman from Arizona, Mr. Stanton, for 5 minutes.
Thank you very much, Mr. Chairman, for holding this hearing, and to the witnesses for being here to speak to an important issue as we work to expand access to justice throughout our nation. When I became a member of the Judiciary Committee 2 years ago, one of the very first things I did was to meet with the Chief Judge for the District of Arizona, Judge Murray Snow, and I asked him, how can I help? Right away, he told me about the caseload issues in Arizona and how Congress could do more to expand access to the judicial system to communities around the state. I've been working on this since, and I know that if it weren't for the pandemic, that this is a hearing that we would have had last year. This is a pressing issue in Arizona, where the state makes up a single judicial district. Since the year 2000, Arizona's population has grown by 50%. More people have moved to Arizona in the past 20 years than live in the states of Rhode Island, North Dakota, and Vermont combined. That means the criminal and civil caseload has gone up too, and in that time, we've only seen the addition of a single federal judge in our state, just one. Judge Humitua, as she mentioned, that means that Arizona's federal district judges see a weighted caseload of 800 filings each. The general standard is 430 cases per judge. So in Arizona, we are nearly double that. I'm encouraged by what the District of Arizona would do with more judges. The focus on increasing access to the courts for rural tribal communities is the right one. For those who haven't been to Arizona and may not be familiar with the Navajo Nation, it is the largest tribal land in the country. Its capital, Window Rock, is a 5-hour drive from the federal courthouse in Phoenix. Hopi lands are a 4-hour drive. That's a long way to travel for court, and yet, that is what tribal citizens must do unless Judge Humitua and other federal judges coordinate for the temporary use of a courtroom space with the magistrate judge in Flagstaff, Arizona. When this coordination does happen, and my understanding that it's about once per month, Judge Humitua must drive up from Phoenix, leaving her civil caseload pending to address the criminal caseload in northern Arizona. She does this because she's committed to providing direct access to those in northern Arizona, but it is not a long-term workable solution. We need a permanent federal judge, district judge in Flagstaff to handle the caseload that originates from Indian country in northern Arizona. That's what Arizona will get if we approve more judgeships. In turn, grand jury proceedings would be made up of peers that is more accurately representative of the community. And other district judges would no longer have to travel and leave other also pressing cases pending. Arizona desperately needs more federal district judges. The district court has been working with too little for too long at the expense of Arizonans who should have fair, unobstructed access to our country's judicial system. Additional judges, that's a good place to start. And I have a question for Judge Humitiwa. Are there any lessons that you can share from your experience as a judge of the Hopi Appellate Court that would inform why it's so important to appropriately staff courts that include Indian country land?
Well, thank you for the question, Congressman Stanton. When I was an appellate court judge for the Hopi Nation, it drew my attention to really the limited jurisdiction that tribal courts have, especially in the criminal context. As you know, in my written testimony, I outlined that the federal courts, we act as essentially a county court, handling violent crimes off of Indian nations, homicides, sexual assaults, domestic violence, and the like. And so when a serious crime is committed and it is not picked up by the U.S. Attorney's Office, then the tribal courts have to adjudicate those offenses. And there often are not enough resources in the tribal court itself to appropriately handle those kinds of cases. And in addition, in the civil context, where there is much broader authority for tribal courts, non-members usually are nervous about filing their cases in tribal courts. They would rather file them in federal district courts. And many of my colleagues know, and we do exercise in the appropriate instances, tribal court exhaustion. So we may see a case be filed in federal court in the first instance, which should land in the tribal court. And so we act as sort of a go-between. I also raised in my written testimony that recently, last Congress, in the Violence Against Women Act amendments, there was a contemplation that for cases that were brought of non-Indians committing domestic violence in Indian country, there was an idea that the federal court should act as a reviewing court, essentially an appellate court in some instances. So there are numerous, experiences that I draw upon from that. Thank you for the question.
Thank you very much, Your Honor. And Mr. Chairman, thank you for holding this hearing. I yield back.
I thank the gentleman. We will now hear from the gentleman from Wisconsin, Mr. Tiffany, for 5 minutes.
Thank you, Mr. Chairman. And I wish the chairman of our full committee was here today, right now, because once again, we saw the failure of remote testimony today. I could not hear some of Judge Mueller's remarks when she was answering his questions. And we saw this in the full committee hearing a couple weeks ago, where it was very difficult to hear people giving their remarks, committee members, when they were wearing masks. Oftentimes people don't have voices that project the same as someone like myself, and it was very difficult to hear their comments. And as a member of a committee, I really want to hear what people have to say, like Judge Mueller, people testifying here, as well as the other members of the committee, regardless of which side of the committee that they sit on. So this failure is impeding the ability to communicate and communicate clearly. Anyhow, just to make that comment for the good of the order. Judge Burns, I believe you said something about, and I'll characterize it this way, border/immigration issues are a big part of what the cases that you deal with. Is that accurate?
Yes, that's accurate.
And are some of those cases violent crime cases?
Some are. The majority of them are status cases with people who are not authorized to enter the United States coming in. As I mentioned in my written statement, those cases are weighted with less weight than a typical criminal case. But I'm not sure that weighting is accurate, because frequently the status cases involve due process challenges to the manner in which somebody was previously removed, or in the case of a criminal conviction, they challenge whether the criminal conviction was a proper basis for their removal. So these cases typically involve motion hearings. They involve a lot of research on the part of the court to look at perhaps state court cases, state court definitions of crime. So they're very time consuming.
Mr. Chairman, I would make the case that with better border enforcement, we could probably reduce some of the caseload for the ninth court. I would turn to Mr. Fitzpatrick now. It seems like the point of some of the people testifying here today is that there needs to be more judges. And what I'm hearing from you say is you're saying that the ninth should be split. Are these mutually exclusive questions, or could there be a greater number of cases that could be resolved if the ninth was split and we wouldn't have this same backlog that some are talking about?
That's a great question, Congressman. I think it would definitely help with the speed of resolution of appeals. And so I think if you split the Ninth Circuit, the appeals would be decided more quickly in each of the two smaller circuits. And so that would relieve some of the caseload pressure that's currently on the Ninth Circuit judges, because they'd be able to get through their cases more quickly. I don't know if it would help as much with the trial level caseload pressure.
Mr. Chairman, is this subcommittee going to be considering or talking about splitting the ninth? Is that something that's going to be discussed?
Well, I'm not ruling out any measures that anyone might want to propose to the subcommittee.
Mr. Chairman, did you consider inviting Mr. Scott, who was alluded to earlier, that has done detailed statistical analysis on this? Was he considered as an invitee?
Yeah, we'll consider all witnesses, particularly those who are unbiased, to appear before the committee.
I really appreciate that. I think that's something that's really missing here today is what I'm hearing is that this Kevin Scott has done, I think I got his name correct, has done a detailed analysis, and we always want to use the best data possible. And to have data like that might be really helpful. And if anyone, Mr. Fitzpatrick or anyone else has information that they can share with the committee that bolsters this point that, that Mr. Scott makes, that would really be helpful. I want to thank you so much for giving me the time, Mr. Chairman. I yield back.
Thank you, Representative Tiffany. And next we will go to the gentleman from Tennessee, Mr. Cohen, for 5 minutes.
Thank you, Mr. Johnson, and I want to thank you for calling this hearing and for the witnesses that appeared before us today. We had a hearing last on the issue of the Supreme Court decisions they've given without the shadow docket. And at that time, there were different witnesses, of course. It was a different issue before us, but I did ask the witnesses if they felt that there was a need for more reform and maybe more addition to the Supreme Court. And they didn't really think there was so much need at the Supreme Court, but they felt there was a great need at the appellate court level, that the appellate courts there needed to be more judges at the appellate court level, the Circuit Court of Appeals. Judge Mueller, do you agree that there needs to be additions to the, I think since 1990, there haven't been any new appellate circuit benches created, and I think the caseload's increased by 19% in appeals. Do you think there needs to be more appellate judges?
Again, Congressman, thank you for the question. I'd clarify, I haven't studied up to answer questions based on the appellate courts in particular, but I know generally that our administrative office has identified the need for more appellate judges in many parts of the country. And so I'm certain there is a need. My focus is on the trial court's need, where even if the law is better clarified by reform, I would observe I'm not certain that would stop the number of cases coming into the trial courts. Our population in the Central Valley and Sacramento Valleys is hurtling towards 8.4 million. People and demography drive caseload filings. And so that is our issue here in Central California. We have wide swaths of public land. We're top 10 in civil rights cases, non-prisoner civil rights cases. We have any number of cases soup to nuts. And I believe that trend is going to continue. So I'm here to tell you, we implore you to remember the trial courts, the foundation of the federal court system. We believe public trust depends on our being fully fixed as well as any other court that needs a fix. Thank you, sir.
You're welcome, Judge. Let me ask you this, and I guess this could go to any of the questions, people on the panel. Does diversity make a difference in the courts as far as the results? And I know they call people Trump judges and Obama judges and all that, but diversity does have an effect on the bench, does it not, in people's perspectives and backgrounds and life experiences?
Again, Congressman, I'm not prepared to address that in any great detail. Generally, if we got the 5 new judgeships we believe we qualify for, particularly if this is the time to fix the infrastructure, certainly we would have 5 colleagues join us. And so there would be the chance to expand our numbers. I do think it makes sense to have society as a whole represented on the bench in terms of maintaining the public trust.
Mr. Fitzpatrick, do you agree with that?
I do. I have to tell you that there's very good both theory and empirical evidence that having a diversity of perspectives really improves decision making. There's an entire field of literature called the many minds literature or the wisdom of crowds. And one of the big benefits of having diversity is you get different perspectives and people's mistakes can be corrected by one another. So I think it's a definite gain.
Judge Levy, do you agree that diversity can affect outcomes and be important for the court to reflect American?
Yes, I think I was just elevated to a judge, and I should say I'm just a lowly professor, though I do have life tenure. Yes, absolutely. I mean, as Professor Fitzpatrick said, there's great literature on this. There's no question that it increases the sociological legitimacy, that is, the perception of legitimacy on the part of the public to see themselves reflected back. I would also point out that this was a real priority before the 1978 Omnibus Judgeship Bill. Right, the real sense was we needed to diversify the federal bench, and we saw that accomplished during that time.
Professor, I've got 20 seconds left. I want to thank you. The fact Congressman Issa suggested we create new judgeships, but we put them off till the next president. The last president appointed over 60 appellate court judges, and only one of them was African American. The country and diversity and African Americans can't wait to the next presidency when they have been done such a disservice by the previous president, who could only find one African American worthy of serving out of 60 or 65 appointments. And if there's a need for more judges, there's a need for more judges. Now, justice delayed is justice denied, and not having diversity, which has increased so much with the last president, is justice denied, justice delayed, justice denied, for our country not being a rainbow reflecting all of us in the country. And Ms. Levy, I apologize. I just generally think Levy, I think of judge, I think Levy, I think of doctor, I think Levy, I think of Rob Red, but now I think of it as professor. Thank you. I yield back.
May I respond?
Well, the gentleman's time has expired.
Well, respond about Rob Red, that's okay.
But I'll allow the witness to respond.
Thank you. I think I won't say anything about rye bread. I will just point out, though, that all the other times in which we've added judgeships to the courts of appeals, we have not staggered them. And again, from a caseload perspective, I would say if there's a leak in your roof, you don't want to hear that you're going to have someone fix it a year from now or 4 years from now. You want it fixed as soon as possible. Thank you.
Thank you.
Thank you.
At this time, we will recognize the gentleman from Kentucky, Mr. Massey, for 5 minutes.
Thank you, Mr. Chairman. The leak in the roof seems to have happened several years ago, and Chairman Issa, or Ranking Member Issa, tried to fix the leak. So I think we should take time to do it right if we've taken this much time already. Judge Burns, I'd like to address my first question to you. The late Chief Judge John Roll of the U.S. District Court for the District of Arizona said back in 2011 that federal courts in Arizona were drowning in a tsunami of criminal cases filed as a result of a surge in federal law enforcement agents working to secure the border with Mexico. He said back in 2011 that more judges were needed due to the high immigration caseload. I wanted to see if you have thoughts regarding how our lack of border control, lack of a strong immigration policy has perhaps led to the need for an increase in the number of federal judges in the lower court.
Thank you, Congressman. I can't speak to need for additional legislation. I can speak to the impact on our court, which, as I mentioned, is one of the 5 border district courts. Our caseload is predominantly concerned with immigration type cases. These include not only status cases, it includes crimes along the border, it includes alien smuggling, it includes drug smuggling. So I agree with Judge Roll's comments from both 2011 and then later. The situation has not changed. In the years, now 23 years that I've been on the court, it hasn't changed. As you heard in my biography, I worked as a federal prosecutor. It hasn't changed since 1985. So those cases are the staple of what we do, what criminal cases we handle here.
And what percent of your cases are dealing with crime or crime-related, immigration-related crime or crime related to drugs coming across the border?
Well, as I mentioned in my statement, fully 89% of our criminal docket includes those 2 categories of crime: drug smuggling, and we're not talking about minor amounts of drugs. We're seeing increasingly 40, 50, 60 pounds of actual methamphetamine being brought across in vehicles. But between border drug smuggling and immigration offenses of the type that I've mentioned, not just status offenses, but alien smuggling and other types of immigration offenses, 89% of our caseload, criminal caseload, concerns those categories of cases.
Thank you very much. Professor Fitzpatrick, you mentioned about the dangers of stacking one circuit by allowing too many partisan nominations in any given year, and that many of the appeals from the Ninth Circuit have been overturned by the Supreme Court. Now, a lot of those are overturned 5-4. Those could be differences of opinion or viewed slightly differently. But are there any cases of where the Supreme Court unanimously decided against the Ninth Circuit in a sort of what were you thinking kind of way?
Yes, there are, and I allude to some of this data in a footnote in my written testimony, but you can slice the numbers as Supreme Court reversals by any vote compared to the number of appeals decided. The Ninth Circuit's number 1. You can slice the data unanimous reversals by the Supreme Court compared to the underlying appeals decided by a circuit. Ninth Circuit is still number 1. And then even better, you can slice the data looking at reversals that were so obvious that not only was it unanimous, but the Supreme Court didn't even bother to hear oral argument. They just summarily reversed on the cert petition and the briefing. And the Ninth Circuit's number 1 on those as well. So no matter how you slice the numbers, the reversal rate and the Ninth Circuit is number 1.
So there have been many 9-0 unanimous decisions overturning Ninth Circuit?
Yes. Yes, unanimous, and even unanimous on the briefs without even hearing argument, called a summary reversal because it was so obvious the Ninth Circuit was wrong.
In those cases, that seems like a clear mistake, a miscarriage of justice instead of a difference of opinion.
I completely agree with you.
Well, I'd like to yield back to the chairman and thank him for giving.
Would the gentleman yield?
I will yield to the ranking member.
In those cases, Professor, weren't a good many of them 3-judge panels in which there was no en banc, and as a result, it was a microscopic portion of the circuit?
That's correct.
Thank you. We will now go to the gentleman from New York, Mr. Jones, for 5 minutes.
Thank you, Mr. Chairman. And thank you all for appearing before us today On behalf of the American people, I'd like to particularly express my gratitude to Chief Judge Mueller, Judge Humatewa, and Senior Judge Burns for discharging your duties under such challenging conditions. As a former law clerk in the Southern District of New York not too long ago, from the years 2014 to 2015, I am intimately familiar with the burdens placed on Article III judges and their law clerks with respect to what are mounting controversies that arise under federal law. It is for this reason that I'm a bit disheartened to hear a number of my Republican colleagues suggest a tactic, an approach rather, that would effectively amount to delaying justice for the purpose of satisfying some of them that their preferred president gets to appoint a number of the judges that we must add immediately to the lower courts. Also, based on my experience, and due to the intensive demands on our justice system, as you have illuminated, we need obviously to expand these courts to expand access to justice. I want to emphasize that expanding the courts will also help us ensure that they reflect the diversity of the American people and the underrepresented perspectives of attorneys who have devoted their careers to public service. President Biden has committed to building a judiciary that truly represents America, and by expanding the courts, we can help him achieve that goal faster. Finally, I'd like to thank my colleagues for their long-standing bipartisan recognition of the urgency of court expansion. I'm hopeful that my colleagues across the aisle will continue their commitment to giving our justice system the resources it needs to fulfill its vital mission. Now, Judge Humatewa, in your testimony this morning, you suggested that because of your district's resource deficits, the juries who hear cases affecting tribal members are often unrepresentative of tribal nations. I'm committed to ensuring that our juries represent our communities. That's why I introduced the Juror Non-Discrimination Act, a component of the Equality Act, which the House will pass tomorrow. Could you explain how expanding courts like yours is important to guaranteeing everyone has a trial by a jury of their peers?
Yes, I want to point testimony in northern Arizona, where we have 10 tribal nations. We also draw our jury pool from northern Arizona, the 5 counties, which include the tribal nations. And so oftentimes, if we have to have a trial in Phoenix for lack of an ability to use our magistrate judge's courtroom, we're essentially asking all of those individuals from northern Arizona to drive 4, 5, 6 hours to Phoenix, Arizona to serve on a federal trial. And many times, the individuals who suffer logistical challenges, hardship, transportation, all of those issues that get in the way of their ability to leave home for a week at a time to serve on a jury, it weeds out a lot of the individuals from many of those communities. And so what ends up happening is you may have a Native American defendant, the victim is Native American, the tribal investigators investigated the case, and you have no Native Americans represented on the jury. It simply doesn't reflect the communities. And that is also true in many instances in our Tucson division of courts. And so we see it in real time. And we hope that with the addition of new district court judges, that more and more of my colleagues will be able to bring justice closer to those communities so that there can be full participation of the communities affected in these jury pools.
Thank you so much. And with my 40 remaining seconds, I'd like to ask Judge Mueller to talk about how her overwhelming caseloads affects the most marginalized parties that appear before you, like indigent defendants, including people who have to represent themselves pro se. And if there are any particular cases that come to mind, if you could elaborate on those.
Thank you, Congressman. We do have a steady diet of cases filed by persons representing themselves. We have robust panels of attorneys that we can appoint, but to appoint, we need to determine whether or not a case has sufficient merit, and that takes time. We have able assistance from our magistrate judges. We have a very healthy number of magistrate judges assisting, but magistrate judges do not have dispositive authority. And so a magistrate judge may see something in one of those cases, but then it gets in line before one of us. Times to disposition in civil cases, and again, we're top 10 in the nation in non-prisoner civil rights cases. Those times are stretching out to 5 years or more, and in pro se cases, they can take the longest.
Thank you. I yield back.
Thank you. We will now hear from the gentleman from North Carolina, Mr. Bishop, for 5 minutes.
Thank you, Mr. Chairman. I was scratching my head for much of this hearing over why it is now only that we have the hearing on the possibility of expanding judges. Many have commented on that. And of course, Mr. Shabbat asked Professor Fitzpatrick about the possibility, I guess, of a partisan desire to control those appointments. But I thought that Chairman Johnson, in a moment, sort of spoke the quiet part out loud, and I wanted to ask about that. He asked about the possibility of needing to expand the United States Supreme Court. And last week we heard in a hearing much about what they call the shadow docket summary, the Supreme Court orders list, or just the summary adjudications there. I think that to the extent that expanding lower courts may be a ploy to render the Supreme Court less able effectively to manage them, that begins to be a fairly apparent purpose. Professor Fitzpatrick, let me ask you, you testified a good bit and wrote about the reversal rate in the Ninth Circuit, if that reflects to any degree recalcitrance at a lower level or unwillingness to recognize that we're in a hierarchical judicial system in which lower courts owe their allegiance to the law as declared by the United States Supreme Court, if you take that situation in the Ninth Circuit or assume that and you increase the number of judges without the structural reforms you've spoken about, wouldn't the result likely be increasingly to overwhelm the United States Supreme Court's ability to supervise the lower courts and to enforce adherence to the law it declares?
I think so, Congressman. I think that if you add more judges to the Ninth Circuit without restructuring the Ninth Circuit, you're going to get more erroneous 2-judge majorities on 3-judge panels, and you're going to get more limited en banc reviews that do not reflect the larger circuit, because only 11 of the bigger number is going to be sitting en banc. And so there's going to be more errors the Supreme Court will need to correct. And the question is, does the Supreme Court have the resources to catch all of the errors? They don't catch all the errors now, and they're not going to be able to catch them all in the future. And if I could just briefly respond to the notion that expanding the Supreme Court might help the Supreme Court decide more cases, I don't think it would. And I don't think it would because the Supreme Court sits as a full court. Right. And so if you increase the number to 11 or 13, it's not going to help them take more cases because now all 11 or 13 is going to have to weigh in on each and every case. Only if you were to ask the Supreme Court to serve in like 3-judge panels could it help, but no, I'm proposing that.
And that would undermine other interests as well, I would suggest.
Yes.
Professor Levy, if I could go to you for just a moment. One of the things about your material is that it sort of covered the length of time that this situation's been the case, at least at the Court of Appeals level. And Congressman Massey spoke to this, I think, a little bit as well. But it struck me, I think you said that the Court of Appeals filings per judge are now down from the peak. There was a peak in 2005 at 400 per judge, I believe it said, and now it's down in 2019 to 284 per judge, and that it's stabilized over the past few years. One of the judges on the panel, I think Judge Mueller, spoke to the fact that population drives increases in cases. I wonder if you have any insight as to why that the caseload has not continued to rise, notwithstanding that Congress last added Court of Appeals judges in 1990.
Of course, and I just want to say it's nice to see someone from North Carolina.
Likewise.
So regarding The 2005-2006 jump, so those were due to two really sui generis events. So first, we saw substantial upswings in criminal appeals and original proceeding petitions. This was following the Supreme Court's decisions in Blakey versus Washington and then Booker. So those were big sentencing cases that had to move through the system. At the same time, we saw a substantial growth in administrative agency decisions. This was following a DOJ decision in 2002 to streamline the procedures at the BIA. So a large backlog of immigration appeals then had to move through the system. They have moved through, and that's why the caseload has now stabilized. But the key point I would say again is that we are up 20% from where we were in 1990. So that slight coming down from the high water mark, I don't anticipate extending. We should see the caseload continue to rise.
Thank you, ma'am. The leak in the roof's been there a while. Mr. Chairman, my time's expired.
I thank the gentleman from North Carolina. We next have another representative from North Carolina, the gentle lady, Mrs. Ross. For 5 minutes, you're recognized.
Thank you so much, Chairman Johnson. And just to let you know that the gentleman from North Carolina and I were in the same law school class. And so the University of North Carolina is very proud to have two members of Congress right now from the same class. And ironically, that class was the class of 1990, the last time that we expanded the judges in the lower federal courts. And so maybe we're here at precisely the right time to do some good bipartisan work. I wanted you to know, and I'm sure that everybody knows, that North Carolina has had tremendous population growth without any increase in judges. As a matter of fact, we may even get another congressional district this next round of redistricting. My district sits in the Eastern District of North Carolina, and since 1990, we've had more than an increase in population of more than 160%. So in the district that I represent, which is where the state government capital is, and a lot of lawyers, we add 60 people a day. Back in 1992, there were 1,817 new cases filed in the Eastern District. That number jumped to more than 3,100 in 2020, which is a 71% increase. And the number of new filings has gone up to 777 per judge. I think it's also no secret that because of partisan divides, we've had difficulty, let's just say, settling on new people to appoint, and we had a vacancy in the Eastern District for more than 10 years. I do think that the judges are doing an honorable job. I've appeared before several of them, but really it's not fair to the litigants, and you've heard about that at the criminal level, at the civil level, and it's on us. It's Congress's fault that we have not had the proper administration of justice. In addition to expediting cases, we also need to focus on having judges who reflect the litigants before them. In the Eastern District, we have a very large minority population, and we have not had a minority judge, a self-identified minority judge. And it means so much both to the litigants, but also to the administration of justice that we have people from diverse backgrounds. The majority of law students in 2020 were women, and more than 30% were minorities. Yet among our district court judges, only 32% are women, and less than 30% are minorities. And we have a similar problem on the appellate court. My colleague, G.K. Butterfield, who was served on as a Superior Court judge and briefly on our Supreme Court, has been working on this, and I am a true partner with him. For these reasons, which I'm sure that many of the members of the committee share, we need to expand our federal judges, and we need to do it in a bipartisan way. I do have one question for our distinguished Duke law professor. Thank you for being here representing North Carolina.
We had talked about the fact that there are more and more unpublished opinions at the appellate level, and particularly in the Fourth Circuit, and this is not a new phenomenon in the Fourth Circuit. I was very frustrated by it as a practicing attorney. I'm interested in knowing whether there's any trend in the types of cases. As Congressman Cohen talked about, we talked a little bit about the Supreme Court shadow docket and what kinds of cases might be in the shadow docket. Is there a similar correlation in the appellate courts?
Absolutely. Thank you. And I should say, since we're required to tell the truth, I am a Tar Heels fan, despite the fact that I work for Duke. So it's a terrific question, right? Are there certain kinds of cases that we see both resulting in unpublished decisions, but also thinking about the front end that don't receive oral argument? And I would say the answer is yes. As a whole, if we were to make a generalization about the dockets of the federal courts of appeals, we see pro se cases largely ending up on this, what has been called a kind of track 2 treatment, immigration appeals, Social Security appeals, those in general, prisoner appeals tend to be, again, put on that kind of track 2. I think that's a fair characterization.
Thank you very much. And Mr. Chairman, I yield back my time, my 2 seconds.
I thank the gentlelady, and at this time we will hear from the gentleman from Wisconsin, Mr. Fitzgerald, for 5 minutes.
Thank you, Mr. Chair. More of a comment, and if somebody would want to maybe jump in, they could. You know, in Wisconsin, we have the Western District, which oftentimes philosophically doesn't necessarily match up with the Seventh Circuit in Chicago. And it's been frustrating over the probably last decade, I would say, in that some of these rulings that come out of the Western District, oftentimes either because vacancy or, not really sure, it's kind of a mystery, but it takes years and years for rulings. We just waited 3 years for a ruling on a bill that had made it through the Wisconsin legislature and was challenged in the Western District. So my point is, I think because of retirement or because of illness in some cases, I mean, there's so many different reasons that the Seventh Circuit will hold something or not act, I guess is a better way of putting it. It's just a contributing factor that I think is so frustrating for those that are trying to develop legislation, full authority of, the legislature to pass it, governor signs it into law, and then it's held up in court. So I'm not sure if anybody would like to comment on that, but it was something it's a real life example of something that we continue to live through in the state of Wisconsin. And it's the dynamic between the Western District and the Seventh Circuit in Chicago. Mr. Chair, I would yield back to the ranking member.
Would the gentleman yield?
I would, yes.
For the two judges from California, both of you in the Eastern and the Southern District currently have vacancies. Is that correct? One in the Eastern and then 2 in San Diego, or is it more? 2 in the Eastern. And Judge Burns, how many vacancies do you have now that you're on senior status?
We have 5, Congressman Issa.
Okay, so we have 7. I just want to point out that those are the result of blue slips, correct? Basically, there were nominees, but they weren't able to be moved forward. Is that correct?
That's correct in the Southern District.
Okay, so
Yeah, I can't say that we know, but our nominees did not get out of Senate Judiciary Committee last year.
I interviewed all of them, so I have a tendency to know some of them. The reason I point that out is that during the intervening time, particularly in the Southern and Eastern District, could you opine briefly on how you used visiting judges and other techniques to try to stem what would have otherwise been an insurmountable caseload?
I can go first. Again, we do have the 2 vacancies. They're over a year old now, and with my written testimony, I provided the standing orders that the one judge who sits in the Fresno courthouse, where those 2 new judges will sit when appointed, issued standing orders explaining the emergency circumstances, the inability to preside over civil cases, and he's holding 4 criminal cases calendars a week. We have used visiting judges to the extent we can. I have just seen the approval for a visiting judge to assist us. Visiting judges can help, but they typically do not own caseloads from start to finish. Federal trial judges own caseloads from start to finish, and without resident visiting judges are not in a position to provide us with the help we need. We've at times had almost 100 visiting judges. When they come, just one more point, they don't come with the full complement of staff. Each district judge draws on staff from the clerk's office, courtroom deputy, court reporter, in addition to our law clerks. So we have about 3 extra staff. No visiting judge comes with that staff. And so a lean and mean staff is then stretched to try to support that complement. They help, but they are no fix.
Thank you. And Mr. Chairman, hopefully this will be a point that we study in order to make sure that we actually fill those to stop this practice of visiting judges that tend to be, as she said, very inefficient. With the remaining time, Professor, could you give us a brief summary of your view on the possibility of doing something in the Ninth Circuit similar to Justice White's proposal?
Is that for me, Congressman Eisman, or Professor Levy?
Oh, I'm sorry, for you.
Okay, thank you. So Justice White's proposal on the White Commission was to basically create another level of appellate review, en banc review, if you will, in between the full court and the 3-judge panel. So he wanted to divide the Ninth Circuit into divisions rather than separate circuits. They'd be separate divisions. Each division, I think he wanted 3 divisions. Each division would have its own en banc. And then if there was disagreement among the divisions, it would go to a full court en banc, but it would only be 13 of the judges on this full court en banc. So it's going to be a small minority of the entire circuit. And so it's that last step that I still don't care for. It's still a limited en banc. And so there might be some improvement with the White Commission proposal, but I don't think it gets us as much improvement as if we just split the Ninth Circuit up into separate circuits where each one could have their own full court en banc.
Thank you, Mr. Chairman. Thank you.
Thank you. Waiting patiently has been the gentleman from Colorado, Mr. Neguse, and he is now awarded with 5 minutes.
Well, I thank the chairman, and I certainly have enjoyed the hearing and very thoughtful testimony from all the witnesses, and appreciate their testimony. And of course, thank you, Chairman Johnson, and to Chairman Nadler for holding this very important hearing. I, like many of my colleagues who participated in today's hearing, represent a state that is in tremendous need of new lower court judgeships. It's become a common theme that I've heard over the course of my time in Congress from stakeholders in Colorado. And to address those needs, I'm introducing a bill today to authorize additional district court judgeships for the state of Colorado, and also to add Fort Collins to the list of places that the district court is authorized to hold court. I represent Fort Collins in the United States Congress, and like a lot of states represented by my colleagues, Colorado's population has skyrocketed, especially in northern Colorado over the last several decades. And while our population and the caseload has certainly grown, the number of judges we have added to the federal bench has not. So again, I want to thank the chair for holding this hearing to bring light to the tremendous need to expand our lower courts across the country and the consequences for not doing so. And I certainly want to thank all of our witnesses, and in particular those members of the federal bench, for their service to our country and to the judicial system, and for offering their testimony today with respect to this very important issue. And with that, I'll yield back the balance of my time. Thank you, Mr. Chairman.
I thank the gentleman. We have come to the end of the road. Gentleman from Oregon, Mr. Bentz, will take us home with 5 minutes.
Thank you, Mr. Chair, and to everyone's relief, I yield back.
That was a quick trip. This concludes today's hearing. Thank you to the panelists for attending. Without objection, all members will have 5 legislative days to submit additional written questions for the witnesses or additional materials for the record. And with that, the hearing is adjourned.